Here at the Payday office today, we have Ms. Terri Olson. As I'm sure you might have read in her bio, she's the founder of HR Prescriptions, a human resources consulting practice located in downtown Fullerton. So without further ado, I'll go ahead and hand it off to Terri.
Good morning, everyone. First of all, I would just want to do my disclaimer that I am not an employment attorney, so this information is just based on research and information that is out there regarding new bills and laws that we have to comply with, and so just keep that in mind. So let's talk, see what we're talking about today. So we're going to be talking about the newest on independent contractors versus employees. That has become a big issue for many employers. And then the new statute of limitation for filing a harassment, discrimination, or retaliation complaint. There's new legislation on arbitration agreements. Also, the employee's right to recover civil penalties for unpaid wages. And then also the new hire provisions on settlement agreements, more lactation accommodation requirements, a hairstyle discrimination law that was put into play, and also the increased benefit program, the insurance for the paid family leave insurance program, and the quick review of the California Consumer Privacy Act where it impacts your employees, and then the minimum wage increases for the various positions. So let's start with AB 5. This is the worker status of independent contractor versus employee. Some of you may have done a little reading on the Dynamex operations lawsuit versus Superior Court. So we've known that about this ABC test for a while. It makes it really difficult for you to have a contract with an independent contractor. I've had several clients who have hired people that they say, well, these people are employees and these people are independent contractors. And I say, well, what's the difference in what they do? Oh, they do the same thing, but these people don't want to be employees. They want to pay their own taxes. And that's problematic. That was already problematic. But now with this decision, the ABC test, that will be really impossible to comply with. So with the ABC test, this isn't an either or. For someone to be an independent contractor, they have to meet all three of these requirements. So the worker has to be free from, and important here, the control and direction of the hiring entity. So we'll just say the employer, in connection with the performance of the work. So that's both under the contract for the performance of the work. And in addition to that, the worker has to perform work that is outside the usual course of the employer's business. And then the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work that they're performing for the hiring entity. So again, your independent contractor, if you have some, they will have to meet all three of these provisions on this ABC test. This will apply retroactively to the California Industrial Welfare Commission wage orders. Those are the orders that you should have posted with your state and federal employment posters. And it also is retroactive to the Labor Code and the Unemployment Insurance Code. Now, effective July 1st, this ABC test will apply for the purposes of workers' compensation. Penalties, if you have people in these, that should be employees versus an independent contractor, and you continue to keep them in that classification, if that would be a willful violation, it could be cost you $5,000 to $10,000 per person, and then there are higher penalties if an employer shows a pattern of violating this ABC test. So one of the I say note here, but really should say warning, because if you have someone that you change from an independent contractor to an employee, you may have to address the issue of them saying, well, what about all the overtime that I worked when I was an independent contractor? Or what about the breaks and the meal periods that I didn't get while I was an independent contractor, or I was misclassified as such? So I can see the plaintiff attorneys maybe having a field day with this if they find out that someone was an independent contractor and switched to an employee, and this could be problematic. So just be really aware that at least moving forward, you are classifying people accurately within these ABC tests. So that's one. And then AB 9, this extends the statute of limitations on harassment, discrimination, and retaliation claims. What it does is that if an employee files a claim of discrimination, harassment, retaliation with the Department of Fair Employment and Housing, it used to be that they had 1 year from the event to file that claim. Now they have 3 years. This actually was a bill similar to this was proposed last year, and that Governor Brown vetoed because he said that 1 year keeps everyone's mind fresh on what happened and witnesses and information. It also required employers to resolve those issues quickly. With 3 years, of course, my thought of this was that, gosh, you could have some of your witnesses, or maybe somebody could leave your company and 2 years later file a claim. And there'd be a lot of lost opportunity to collect information on when you're doing an investigation. But here it is, and we have to deal with it. Now, when the employee files a claim with the Department of Fair Employment and Housing, I'll just say DFEH to make it easier, they do get a right to sue letter from the DFEH, and once they have received that, then they can go ahead and file civil action in court. Now that they have the 3 years, that means that instead of 1 year, now really they have 6 times longer amount of time to file that. So if they have 3 years to file that, that means it could be, another 4 years. So really, you could find yourself defending a claim that occurred as long as 4 years in the past. Now, if there is an expired claim, that does remain expired. So it doesn't bring up old claims and extend those. So be aware of these changes, and also make sure that your harassment policy is updated. I know that I had my attorney review the one that I had written, and we kind of combined it and put our heads together to make sure that it complied with all the new regulations and the people that are protected, etc. Make sure that you follow those internal procedures that you have in your policy when you do investigate a complaint. And then also, your investigation file should be kept separate from the personnel file. You don't want to commingle those. And I would make sure those are locked up, and that only the people that are responsible for conducting the investigation, which is usually your HR team, they are the only ones that should be able to see those documents and have access to them. The next one is on AB 51. This places prohibitions on arbitration agreements. It seems that arbitration agreements are getting more and more difficult to even use anymore, but AB 51 bans mandatory arbitration agreements when it's a condition of employment, or maybe continued employment, or maybe you're offering a certain employment benefit related to them signing the arbitration agreement, or waiving any right to pursue either a PHA, which is the Fair Employment and Housing Authority, or a labor code claim. So you can't mandate that they sign an agreement. It also prohibits you as an employer from threatening or retaliating against an employee who refuses to sign the agreement, but it doesn't prohibit you from entering into agreement voluntarily with your employee. Obviously you're going to want to think about, well, what kind of perks or something can we offer? What can we do? Not perks, but what can we do to get our employees to sign these voluntarily? And of course, when you have a really great work environment and people are happy and all that, they're far more willing to trust you to have various policies and agreements. The mandatory arbitration ban will only apply to contracts that are entered into, modified, or extended on or after January 1st of next year, the 2020. However, they don't explain what extended means. So that means that if it was signed 2 years ago, that it's extended into 2020, or we don't know. So it would be helpful if they would think those things through. But anyway, employers should, you should consult with your employment attorney and make sure that your arbitration agreements are current, that they are defendable in court if you ever should have a concern with that, or an employee that's concerned with that. On SB 707, this is arbitration agreements all as well, and these are the fees and costs. So it penalizes an employer for failing to pay those arbitration fees and costs within 30 days of when they're due. If that happens where an employer does fail to pay those, it does result in a breach of the arbitration agreement, and as a result of that, you waive your right to compel arbitration. And that gives an employee the opportunity to withdraw from that arbitration and prosecute their claim in court. So look at your arbitration agreement again with your employment attorney, and you might consider reviewing and auditing your employment practices, your procedures, all the practices that you have in place to prevent lawsuits. Not to plug HR prescriptions, but we do HR audits, and many times people stare at me blankly and said, I didn't know I was supposed to do this or that, and I don't know how anyone would know, because once you start a business, it's not like you get a book of rules. Whatever we can do to prevent these complaints and lawsuits, we'd rather be proactive on. So consider that. On AB 673, this permits employees to recover civil penalties for unpaid wages. We have a Labor Code 210, which is already in place, and it just amends it. It gives employees the right to recover civil penalties when they have not received their wages in a timely manner, or maybe not at all. So civil penalties were previously enforced only through the labor commissioner, an action that he or she would provide, and then the new law removes the ability of the labor commissioner to recover those penalties in an independent action. Now the employee can recover statutory penalties either under this new law, AB 673, or under PAGA, which is the Private Attorneys General Act, but they can't do both. It does make employers liable for 25% of the amount that was withheld from the employee for certain labor code violations. Obviously, you look at your termination policies, make sure that you are paying an employee. Obviously, every payday they should be paid exactly what they're due, but when you terminate an employee, make sure that you pay them everything that they are entitled to as of that last day and then within the time frame. And I believe all of you are in California, so you know that if you're terminating an employee, they have to be paid at the point of termination. If they've resigned, then you have 72 hours from the date of, or the time of their resignation to provide that pay. AB 749 is the ban on rehire provisions for your settlement agreements. It prohibits and invalidates any provisions in the settlement agreement, like, for example, a separation agreement that is entered into either on or before January 1st of 2020. It prevents workers from you can't prevent workers from obtaining future employment in that settlement agreement, either with your business or with any of your affiliated companies. It applies to any employee who has filed a claim against the employer in court, before an administrative agency, in an alternative dispute resolution form, or through your internal complaint process. The employee, that if they do file these things, are considered an aggrieved employee or aggrieved person. So if the employee is complained internally and a severance agreement is reached with that employee without them filing any kind of litigation, then you still are restricted from placing a no hire provision in that severance agreement, where maybe before where we would have said that, they're signing off and saying that they will not apply, or they understand they will not be rehired. You will not be able to say that anymore. So once again, contact your employment attorney, make sure that any settlement agreement that you use is updated and that it is defensible. And I really recommend that anytime you terminate an employee, if you're doing a layoff, if you're doing a termination of someone where that's like we've agreed that we're going to part ways, that you have each of those settlement agreements, separation agreements, severance agreements, whatever you call them, that you have those reviewed by your employment attorney, because I know that each situation, at least the ones I've been exposed to, each situation is different. So just make sure that you are protecting your business by making sure that each one of them is accurate for the specific situation. In SB 142, this expands lactation accommodations. Last year we had another law that expanded the original law, and it said that you cannot use for women who are lactating at work, that you cannot use a bathroom, which to me seems obvious, but I know some of my clients have restrooms that have, a little rest area where there's a couch or a chair or something, but now we have additional provisions. These may find it a little challenging. I think I would if I had a large business. It mandates employers to provide a lactation room or a location, which is not a bathroom, and it has to provide all these bullets. So it has to be in close proximity to the employee's work area. shielded from view. So that could be that there would be blinds required, or maybe curtains or something, or just some wall covering over a window if there is one in that room. It has to be free from intrusion while the employee is expressing milk, so that would mean a lock on the door. Safe, clean, and free of the hazardous materials. It has to contain a space for the woman to place a breast pump and any personal items that she has, and a place for her to sit. And also there has to be access to electricity, and the employer, you must provide access to a sink with running water and a refrigerator for storing milk that's in close proximity to the employee's workspace. So when I think about some of my clients that have big, they're not warehouses, but they're production, a plant basically, and lots of production room and stuff. If someone's on the other end of the plant, as opposed to the break room, they don't tell us, of course, what close proximity is, but for some of my clients, I think they're going to almost have to build a room or a section off an area so that there is a private room. These are a lot of provisions to comply with, but that's what we're going to do. And then it also requires you to develop and implement a lactation policy, and it has to state what the employee's rights are to request lactation accommodation, and also what her rights are to file a complaint with the labor commissioner if the employer fails to provide those accommodations. They do equate the denial of the break time or the space to lactate as a violation of a rest period. So that subjects the employer to a penalty of $100 per violation. So obviously this needs some time and attention, and if you need help with the lactation policy or an update to yours, you feel free to contact either me or Hugo, and we'd see what we can do for you. Also, employers with 50 or fewer employees, if you can demonstrate that this would impose an undue hardship, too difficult or too expensive, you can apply for an exemption from this requirement. The attorneys that I work with, one in particular said it doesn't look like that's going to happen. So you can apply, but I would start thinking out how you can comply with this. So when you want to review and update your policy, make sure that it meets requirements of this new provision. Have your company managers and supervisors trained so they understand what the employee's rights are. And then once you have those accommodations available, make sure that your managers and supervisors know, and that any of your new mother employees know where that room is and how they can use that. SB 188 is also referred to as the Crown Act, which is create a respectful and open workplace for natural hair. I don't want to be sarcastic, but I just why would you be upset about someone's hair? But anyway, so here every once in a while we just get these interesting laws that come into play that we have to comply with. But it just expands the definition of race to include traits historically associated with race, such as hair texture and protective hairstyles. So it does prohibit you from having a dress code or grooming policies that prohibit natural hair. So that would include afros and braids, twists, and locks. I see a lot of people, even guys with long dreadlocks, I think they're called, and I think they're pretty awesome. So, but anyway, I guess somebody had a problem with it, so we had to protect them with this law. So just make sure that your dress code doesn't, prevent employees from having some type of hairstyle. The protected hairstyle, if you don't know, it's where someone has taken, and when I look at these, I just think of someone who has that natural fluffy hair like an African American, or one of the high school young ladies that I volunteer with. She's part African American, but part of other things, and she's got this bushy hair. And so when they call it protected, it's where they braid it, or they I don't know how they do it. They make it these beautiful little carvings on their head, and then it keeps it from being all fluffy. But anyway, that's a protected hairstyle, is where it's just kind of tied into place or wrapped into place, looking pretty awesome. Now, the paid family leave insurance, as you know, paid family leave is not a leave of absence. It is an insurance program through the state of California. So you could equate it to to SDI, state disability insurance, but in the case when employees apply for the paid family leave insurance, it's because they are taking care of either a spouse or a child or a parent. And so the existing law has provided 6 weeks of paid family leave, and starting January 1st, they will be entitled to 8 weeks of leave. Now, obviously, you as an employer are not paying for this. It's coming out of the employee's taxes, payroll taxes, but it does require that you would need to approve 2 more weeks off, and I know that especially for small and mid-sized employers, that can be a challenge. It has nothing to do with any length of time that's approved under FMLA or CFRA or other pregnancy disability leave. It's just a benefit for people who qualify for the family leave time off. And then under 688, this expands the Labor Commissioner's authority to pursue wage claims. This law, previously the Labor Commissioner could only enforce actions for violations alleging unpaid minimum wages, but this new law provides the Labor Commissioner with the authority to issue citations for violations of unpaid wages that were less than the wage set by contract in excess of minimum wage, which is just a mouthful to say pay your people on time and all that they're due. Employers should be very mindful when terminating employees. Make sure you're paying them correctly, as I mentioned earlier. Pay them within the time frame, pay them what you are due. I know the only exception to not giving somebody everything they're entitled to is if they're on commission. You have the right to go ahead and process your commissions as you normally do and pay them after that. If an employee who has been terminated calls the Department of Labor and says, I wasn't paid my commission, I have found that they usually say, well, they have to pay you that. But when you look at the law, it says that you, as an employer, have the right to follow your due diligence before you pay out commission. They don't always get the right answer when they call. SB 778 is the extended deadline for sexual harassment training. You probably already know about this, but last year we were informed that we had to, if you had 5 or more employees, you had to provide mandatory sexual harassment training to all of your employees. Those of you who have had 50 or more employees have been training your supervisors, managers, leads, anybody who directs the work of others. You've been training them every 2 years. Now this training is for 5 or more employees. So they passed out, said you have to have all this done by January 1st of 2020, and then late in September, late in the year, in September, they said, well, we'll give you another year. After all of us, or many of us have already done the training. So the training is required every 2 years from the date that you do it. You just count every 2 years and get everybody trained. Make sure that the trainer that you have and the training program meets all the criteria. You have to train your non-supervisory staff for 1 hour, and then your leads, managers, supervisors, anybody above that for 2 hours. And it does have to include abusive conduct, which we call workplace bullying. That topic has to be included. Our program that we do at HR Prescriptions, we have everybody gathered together for the first hour. Then when we're done with the general information, we excuse all the non-supervisory people, have the supervisors stay, and then we continue on with the next hour for them. And that makes it a little bit easier once you get everybody together, because sometimes that's not easy. New employees do need to be trained within 6 months. So from 6 months from the date of hire. And then interestingly, when they changed the date to 2021, they didn't address or correct that if you have seasonal or temporary employees that are going to be working for you for less than 6 months, they do need to be trained within 30 days or within working 100 hours. Some of these, I know I have clients that don't have that many employees, so I'm going to be putting together a program that's just almost like a public program where people can come and get that training every 6 months, and then you could always send your employees to us to get trained. But otherwise, you might look into, if you do live training, which my employment attorney always recommends so that employees have the opportunity to ask questions and all of that, then they will, they miss out on that opportunity if they do online, but online is obviously very cost effective. California Consumer Act, I'm just quickly going to jump to the bottom line here, because if you just need to make sure that under the CCPA that you are your employment applicants and employee information is kept separate from any consumer or client information that you obtain for business reasons. This just seems minor compared to other things. I did want to get onto the California minimum wage. As you know, this has been increasing $1 each year. So whether you are 26 employees or more or less than that, you will see that we've tried to fold it a little bit here, that you're either at minimum $12 an hour or $13 an hour. Now, whenever the minimum wage increases, then of course the minimum requirement for exempt increases. And so I have listed there the minimum for anyone who is in an executive, professional, or administrative exemption classification needs to be paid either $1,040 a week, $4,500 plus a month, or $54 plus a year. Now, if you have offices in Los Angeles or city of Modesto, and there's several other cities. Emeryville, I know their minimum wage is 16 something. So you have to look at what your city has to make sure that you're paying the correct minimum wage. Also, the Department of Industrial Relations looks at the computer professional every year and determines if an increase in that minimum has to be established for them to be exempt. And so these are the increases for the new year. Some people we always call them the computer guy or the computer girl or something, but whoever we have managing our computers, you have that person as a salaried employee, they need to be making at least this much. And that's just a 2.5% increase in the California Consumer Price Index. So we have no time for questions, but if you do have questions, feel free to put those in the question section, and we can maybe get back to you. Or do you have time?
Yeah, we will try to funnel them. So we are at the 30-minute mark. I did have just one question that came in later. Anything else, I will go ahead and just funnel over to you post the webinar.
Okay.
But in regards to the lactation, I believe it was, and the running water, the question was, can the running water requirements be a bathroom? I know you were talking about it can't be a bathroom, but I think they might be referring to like everything else in one area, but they can run over to a restroom.
You know, I'm picturing when I go into a department store, and sometimes they have a lounge in the women's area, of course. They have a lounge with chairs and seats and things like that, couches, and then there's an opening to the stalls where there are the sinks and all of that. If you have something like that, I think you could argue that you do have a proper area. The only thing is it's not private. It's private because it's a women's bathroom, so a man can't walk in, and of course women breastfeed in public by just either covering themselves, and in some places they don't. But I would say, I can't speak for the state, but that seems very reasonable if you have that type of a setup where there is a separation from the toilets and the sinks, but the sink is nearby, and you have a couch or a chair of some kind.
Okay. Thank you so much, Terry, for taking the time to answer that.